All right, welcome to the House Judiciary Committee this Thursday morning, May 8th, and have some testimony on H98, and then we'll turn to S12, and we'll start with Deputy Commissioner Erica Radke is joining us. Thank you for being available. I think you're there. Oh, there you are. You just need to unmute yourself. Thank you for being available in such short notice. Over to you as far as we're mainly looking, just for your information, at the sections involving these standby guardianship, not the confirmatory adoption. So if you could weigh in on that and what are the DCF position on that, we greatly appreciate it. So thank you very much.
Great. Thank you. And good morning, everyone. For the record, my name is Erica Radke, and I'm Deputy Commissioner of the Family Services Division of DCF. And I have with me Diane Jabber, who is the director of our Centralized Intake and Emergency Services unit. And I thought it would be good to have her here because her unit is the one that would be on the front lines of dealing with these guardianship type issues. I did watch the testimony from yesterday, so I know you had a number of questions. But at the outset, I just did want to say that we are in support of H98 in terms of the standby guardianship. And I know that there was some discussion about DCF and in terms of our resources. And really, I wanted to just make sure to emphasize our position is that we don't feel children, DCF is for children that are abused or neglected or have some issue of child maltreatment. And that's when we would believe we should be involved in those children's lives. So in these cases where there are children that may have parents that have selected guardians or have an order where the children can be with them, and throughout our checks that we see that their background checks have come through and that there are no issues of safety, we don't believe that DCF should be involved in those cases, and that we would work particularly through Diane's unit to connect with the Vermont Legal Aid to make sure that those kids could be placed then with those guardians. So our position is if there is safety is confirmed and there's a guardianship order, we wouldn't want to unnecessarily involve ourselves in those children's lives. However, and Diane can walk through the process, if it does come out that the guardianship does not pass our background checks, or if there are no guardianships, and then we would necessarily then try to look for another placement. And if that doesn't come through, we would expect to go through our normal process and bring the child into custody.
Okay, so I'll open up for questions. Ken, go ahead.
Do we have ample space if we're having trouble with enough space now to house kids in need or young adults? Isn't this just going to add to the burden? I mean, is there a plan in place? How are we going to arrange this to take care of stuff?
It's unclear at this point how many kids could come into custody. And we really do look at it, we don't have a wait list. So we would need to, if we need additional resources, we would come ask for those resources. We would make the adjustments necessary, because if those children do need to come into custody, that is, what we're here to do. So, but we do like the idea of having this law so that if the children are able to have guardians, then they don't need to come into our custody. And I'm wondering, Diane, do you have anything to add to that?
I would agree. And I would also add, though, if this happens after hours, on the weekends and evenings, we do have emergency foster homes where we could place children, but they are quite limited. They are available, but I think if we had a sudden influx of children coming into custody, it would be a challenge after hours. And I would agree we might need to look for more foster home resources, at least after hours on an emergency basis.
So, so that's where I'm going with this whole thing is I don't want to traumatize, or however you pronounce that word, the kid more than what's already happening. And I know we're already over burdened with these people that are wonderful with the foster homes. I hope we, first of all, I hope it's not needed. Let's just be perfectly clear. Second of all, I just hope somehow or another, DCF is already way overhead already. So I hate adding more stuff to you. My heart goes out to you. Thank you.
Thank you. No, I appreciate that, we do, our limited resources are stretched. And it would depend on how many came in. And as Diane mentioned, overnight is definitely a more difficult time. But the way we're set up is if the children are in need, we do make those arrangements, and we would try our best to make sure to accommodate them. But it would not be an easy task for us by any means.
Great. Thank you.
John and Barbara.
Good morning. One quick question. Is this solely preemptive, or is there an existing problem with these particular children that we're discussing?
There isn't a particular problem. This is more preemptive, trying to make sure that we could have a plan in place to try to avoid bringing in children that, if there is a way to have them not come into custody. And I would also defer to Diane to add anything in additional.
I would agree. At this point, we haven't had to utilize our protocol yet. We also created this 8 years ago in 2016, and we haven't had to implement a protocol yet.
Okay, so I guess I'll further a little more. If it were to happen now, one or two kids, I know that could be a lot when you're already struggling a little bit with foster homes, but you could handle that, correct?
Yes.
Okay,
Yes.
thank you.
Barbara.
Good morning. So I think I heard yesterday from one of my colleagues, like, why not have DCF place a child with the guardian? And my understanding is you could not do that unless they became licensed foster parents. Is that right? Like, you don't have like side kinds of ways to place kids other than to a licensed group home or residential program, or to a licensed foster parent.
Yeah, once they enter our custody, you're correct that they would need to go to a licensed foster home or some sort of approved residential facility.
And to have guardians become licensed foster parents is a big that isn't like you do that in a week. Right? Like, that's a pretty lengthy, and it should be, right? Like, the process is really thorough, and there's training and home study, right? Like, so it just might be helpful if you could just share what the time frame and the process is. I mean, it's always great to have people that want to become foster parents, and maybe somebody through this will be like, oh my gosh, I want to. Too bad Ian isn't in the room, but I want to help more kids in our state.
Yes, it certainly is possible to license potentially these guardians or other kin or people known to the child, but it is a process. They do need to go through not just the background checks, but a social worker has to go to the home and do a suitability assessment. And I think I could say it could be a few weeks, depending on the situation and the potential foster parent. It could be a few weeks before the process is complete.
Okay, interesting. I thought it took longer. Um,
I would add that, I
Yeah.
mean, generally, I'm just thinking, I would add additional time on that because I do know that even with the background checks, there's been some backlog and the
Yeah.
time is a bit more extended. And I'd also be just concerned with uh, the idea of bringing a child into custody if we don't need to. I really think that we should be careful with just overreach.
and I'm familiar with the interstate compact when you work with other states. Is there an inter-country compact at all? Because that also came up yesterday and I just wondered about that.
You know, I'm not certain of an inter-country compact. We would have to check, but I do know that one of the things that came up in the discussion was about DCF's ability to do home studies overseas. And we're in the midst of getting a contract with an organization that would be able to do overseas home studies. So let's say there was a child in our custody and they located a family or a guardian outside of the country, that organization at a cost would be able to perform the home study so that we can ensure the safety that we need in order to do that type of placement. And
Right.
Diane, do you have anything additional on that?
No.
I know we're certainly set up for international adoptions
Mhm.
and having sometimes in-country home studies done, working with a licensed child placing agency. But again, those all seem to then end up being interstate or just going through a Vermont adoption agency.
Right.
But it's very different on the other end of it. So interesting. Thank you.
And this will be a new contract for us. We have not done this type of thing before, so we will have to see how it works out. But you know, I think just as you said, it must be an offshoot of those international adoptions where they've been able to do these kind of out of country home
Right.
studies.
Right. And did DCF want any changes made to the bill? And if so, did those get incorporated?
We had no changes.
Thank you.
Um, if we are able to do this and we can facilitate giving guardianship to somebody outside of DCF, do you anticipate that the state of Vermont will have any further contact with that child set up or anything, or have we relinquished sole responsibility for the child to the guardian at that point?
I think it would depend on the situation. If they go through the guardianship process in probate court, and the probate court judge does not see any concerns, we potentially may not have any involvement with the family. We do have information sharing with the probate court, and it's not uncommon sometimes when there is any sort of guardianship case that probate court reaches out to my unit at Central Intake and Emergency Services, either for information or to make a referral for DCF to get involved. So it could happen through the probate process.
So essentially, after the probate process, everybody's hands are basically washed of the situation. Typically.
It could be, unless, well, it kind of depends on what the probate order is. So if it's time limited, sometimes they'll need to go back to probate court, and at that point the judge will want to know if children still have a safe caretaker. But you know, it is possible that if they go into a guardianship and there are no concerns, that DCF might not be involved.
I guess I would, well, okay, so if the probate judge could do a callback, set it for a certain date, say 60, 90 days out. And under this circumstance, I wonder why, could you give me any idea why they would do that?
Erica, if you have more information, I can speak from my experience at Central Intake. It's often either the guardian is saying they're unable to care for the child, or they need help, or they're having some challenge with caring for the child, or maybe another relative or someone else wants to say, like, might want to pursue guardianship as well. So it may come back to the court in that way.
Okay,
Yeah, and
Thank
I agree with that, Diane. No, those would be the situations I would think of too. But I would agree that outside of those kinds of situations, those guardianships that are, uh, we are definitely less likely to be involved as an agency.
thank you.
Ken?
Again, I think short term, what I was looking at was short term, having something, hopefully this doesn't even become an issue, just that we have things in place, that we have existing foster homes that are already doing this stuff to just offset this, because I have a feeling that this is, if this bill is what I think it's really about, more than likely, federal is probably gonna have much more to be responsible for dealing with this stuff, whether Vermont likes it or not. Would that be a correct assumption, or would you rather not say?
I can't say.
Yeah,
No.
that's okay. I understand. Thank you.
Other questions? So I just want to confirm one thing that we understood from yesterday's testimony. So if DCF takes the individual into custody and then the parent is deported to another country, you can't reunite the child with the parent in that other country. So you have them until they're 18. Was that a correct understanding of what I heard yesterday?
Diane, I'd like you to weigh in first.
Yeah. I think that is the concern. I don't think it's impossible, but this would be new to Vermont, and it would be complicated because once a child enters our custody, we're obligated to ensure their safety and well-being, and we can't release the child to a caretaker unless we know it's safe and a suitable home. So if the parent is in another country, it will be a challenge to do a proper home study and assessment of that reunification. I think, Erica mentioned earlier, we are in the process of creating a contract with an organization that does international home studies. But I think it's just uncharted territory for us. So I think, but part of that is we will try to create a resource where we could do home studies in places like Venezuela or Central America. But I think until we can get this practice established, they could remain in custody a lot longer than may be needed or necessary, because we just don't have the resources yet to ensure a safe transition to their parents.
So, go ahead. I'm sorry, Erica, go ahead.
No, I was going to thank Diane for framing it that way in terms of we're trying to get some resources to facilitate that type of placement. However, we haven't worked with this company yet. We don't know how long it would take. And I do agree that it's new, and we would hope that it would be a seamless process. But I would anticipate that we would have these youth longer than perhaps normal. And that's provided, this contract works well.
So perhaps we can make sure that we do a check-in at the beginning of next session to see how that goes, because the other option presumably is that we can look at possible legislation where if a child comes into your custody through this path that we've been talking about here, that there's a different way to reunite the child if the parent is deported. So, I mean, it's not, I absolutely understand the situation where it's somebody's been, a child's been abused, that one has to be extra careful in reuniting the child. But if there's been no evidence of abuse, it's just a matter that the parent has been deported. It seems like that should be a different path. But it sounds like you have one approach that you're looking at through this contract, but we should plan, I mean, we couldn't put that together with what time we have left this session anyway, but it's something we should definitely revisit to see if there's some legislative changes if necessary. So, yeah, Barbara, go ahead.
And do you know if other states have come up with a system, but when you end up talking to your counterparts, that has worked well? Because I know that this has happened in other states and we have not seen it in Vermont yet, but I'm just wondering if any innovation has come up in your travels or discussions.
I have not heard of anything.
I have not either, but I certainly reach out to my counterparts. This is still just pretty new to us as well, so I don't think we've really had time to do that kind of research.
No, I know you're busy.
I'm with you. I would be very curious as well. I think we could learn a lot from other states.
Thank you.
Yeah.
Are you aware if the federal government has the ability to do reunification over international boundaries?
I'm not aware of that either. And I would wonder just about the tension then between our state-run system and our regulations and rules wanting to ensure safety and how that would interact with the feds.
Any other questions for Deputy Commissioner and for Diane? I don't see, so thank you very much for being able to testify on such short notice. I really appreciate that. And we'll turn to Jill Martin Diaz next. Thank you very much for being here, Jill. If you could identify yourself for the record and proceed.
Thank you very much, Chair Lalonde, and to the committee. For the record, I am Jill Martin Diaz. My pronouns are they, them. I'm an immigration attorney and the supervisor and executive director at Vermont Asylum Assistance Project. I come to you today as one of the two attorneys who provide emergent detained removal defense legal services in the state. So I'm one of the two people who gets called when there is a quote unquote adverse immigration action. And I'm really grateful to be here today to share with you some perspective on what we're seeing on the ground, to address some of the previously asked questions in yesterday and today's testimony, and answer any other questions that you folks have. I'll share just to kind of couch the perspective I'm bringing to this conversation. I have about 10 years of removal defense experience litigating detained cases in New York, New Jersey, and here in Vermont. I teach immigration law. I've taught it doctrinally at the law school and also in the law school clinic, and I teach it now from a policy and practice perspective at University of Vermont. I'm deeply connected with the American Immigration Lawyers Association and the National Immigration Project. We at Vermont Asylum Assistance Project vote very strong support for the combined S95, H98 bills, focusing specifically on the immigration-related issues at S95. We are seeing an immediate need. I know that there's been a lot of discussion about whether this is a theoretical need, whether this is a preemptive, a preventative measure. But in my neck of the woods, we're seeing an immediate need for clarity for judges about the jurisdiction that they already have to make decisions about the well-being of children who are dependent on them for those decisions. I might lead with an example before I share some responses to frequently asked questions I've heard come up. Just yesterday, my staff attorneys who do all of the actual service delivery at VAC, because I spend my time speaking with all of you fine folks, they were in court in a county in Vermont, in a northern county, not to be named, and they were representing a young person who is reliant on the court to make a decision about their custody and care, their well-being, because reunification with one or both of their parents is not viable. And they were asking the court for a consensual guardianship, and also asking the court to exercise jurisdiction to make special findings about the young person's situation so that they could access the full benefit of federal immigration law that allows kids in this situation to access lawful permanent residence, green cards, and to move on with their lives here in the United States. This is a form of protection that President George H.W. Bush signed into law in 1990, and has been growing into a robust national practice to make sure that immigrant children don't become stuck in state DCF custody in any of the states as a result of adverse immigration action taken against parents. It has been the case for decades that it is onerous on the department to enforce removability against children or to arrest whole families. And so this issue that folks are worried about coming to Vermont is something that's already existed for decades. And here in Vermont, this body, as well as the Supreme Court, have made clear in several decisions that Vermont courts have jurisdiction to make decisions about the care and custody of children over whom they have jurisdiction, regardless of immigration status. I worry that because immigration is such a politicized and divisive issue nowadays, that it's distracting from what I think is the heart of this legislation and the heart of what we have long relied on probate judges to do. We have long agreed in our system of checks and balances that trial courts are the appropriate bodies to gather facts and make findings with respect to the best interests of children. And that's been true here in Vermont. So understandably, because immigration is so politicized, as Barb Prine testified yesterday, trial courts are also reluctant to do anything that exceeds outside of the bounds of their authority. And when anyone hears the word immigration, our ears perk up. And the courts have been a little bit reluctant over the years to exercise this jurisdiction granted them by federal Congress. And that is why the Supreme Court of Vermont had to intervene in 2019 with the decision Kotoko v. Salamo, clarifying that yes, indeed, the probate division and the family division maintain jurisdiction over the care and custody and well-being of young people, regardless of their immigration status. And they can and should make decisions to further the best interests of those children and minimize unnecessary institutionalization by the Department of Children and Families. And after the Supreme Court clarified that jurisdiction in 2019, this legislature created two laws. First, you created Act, it's 298, Act 167 in 2020. And then you clarified it again with Act 98 of 2022, making clear that as Congress has stated in its law, as the Supreme Court of Vermont reiterated in its decision, that indeed probate and family trial court judges are the right fact finders on the questions of care and custody of children, and immigration status has no bearing on whether trial courts have the jurisdiction to make findings of fact and issue orders pursuant to those findings. And so I hope to refocus as an immigration legal defense attorney, I hope to refocus our attention on this other area of law that I've come to learn about, not because it's in my bailiwick necessarily, but because I find a lot of my work as an immigration lawyer is to clarify when there are laws that become, they are sensitive to a person's immigration situation or not. And this is one of those examples where immigration status, many bodies, including this one, have made clear over and over again that immigration status is not at issue when there's a question of the well-being of a child or the best interests of the child. What we're seeing on the ground is that right now, ICE interactions are up, right? So Congress has delegated authority to this body to prosecute civil enforcement of removability. And we are seeing the number of arrests and detentions uptick. What we are also finding, and judges are ordering as such, that some arrests are happening in error. There are people being taken into custody in error, even though they have immigration status or are not removable as charged. And we lawyers, our job is to do a review of the case, assert any legal claims and defenses, and bring those Vermont parents home from detention, right? There's still the immediate issue of who's picking up the kid from school today, right? What happens in these moments is that I get calls from school districts, from community health workers, from health centers who are now, instead of providing their services and doing their jobs in an efficient and effective manner, are now all kind of roped into this uncertainty that could have been prevented if we had just given trial court judges the extra reassurance they seek that yes, this is in their jurisdiction as it has been. This recent changes haven't changed the fact that they retain fact-finding jurisdiction over the care and custody and well-being of children, and that they can and should exercise their authority to make findings that prevent children from unnecessary and expensive, and to the representative's point, traumatizing contact with the Department of Children and Families. Nothing about the finding of fact on a child's care, custody, or well-being has any bearing on whether they are removable as charged, except that if there is a person who happens to have other pathways to relief, it keeps them out of institutionalization, and it gives me as their lawyer easier access to them to more efficiently represent them to resolve whatever their immigration matters. And so, I have a few points to raise in response to frequently asked questions, but I might pause there and welcome the committee to direct me further.
Any questions at this point for Jill? Not at this point. If you could go ahead, and we'll see if you catch any of the questions that we've had already. So,
yeah, certainly. So when we're talking about this issue of how we define adverse immigration action in the statute, I think that in this shifting landscape, it's difficult for us to envision what agencies, what resources, what new laws or policies might be mobilized in the arena of federal immigration authority. And fortunately, I don't think we're being asked by your colleagues who have proposed this bill to divine what might be up ahead in the realm of immigration enforcement. Instead, what we are hearing, resoundingly from individuals who represent young people and families, from DCF who has to take custody when the rest of the system fails, from the courts who are seeking clarity, everyone recognizes, as have several other states and jurisdictions, that providing a clarified pathway it's good policy, it's in the best interest of the people. When I look at the definition of the 6 types of adverse immigration actions that might trigger eligibility for the emergency or springing guardianship, I feel like the definition is good enough from a legal perspective. I think it is specific in that it's directed, but also leaves open the possibility of whatever may be coming down the pike in the arena of federal immigration enforcement. Section A covers arrests for immigration, civil immigration violations, criminal immigration violations. Sections B through F cover what usually happens after the moment of contact with the government, detentions, removal proceedings, visa adjudications, exclusion proceedings, appeals. And so it looks to me like the way that the statute has been defined, it's very clever in that it gives us clarity about, it helps judges to feel confident in exercising their jurisdiction over these matters without being unnecessarily prescriptive or exclusive of what might come next. I think my biggest message about what an adverse immigration action looks and feels like is that it is a moment where a person has been charged with a civil offense and no finding of fact has been made. And as a country with checks and balances and a system of rule of law, we don't know what is going to come of that adverse immigration action. And it's really, I don't think that's a question that raises before the probate division or the family division. All that we need to know is that there has been an adverse immigration action, and now if there's already a plan in place for who's going to pick the kids up from school and make sure they have their medicine and make sure that they're fed and have what they need to keep them out of unnecessary institutional custody from the state, that is a good thing. That's good for communities, it's good for taxpayers, and it's good for our service providers who are not in the business of child welfare, really. We want our educators educating, we want our hospitals providing medical care. I heard a question from, I'm not sure who had asked it, about whether or not, why the statute specifies a singular custodial parent rather than a plural parents. And what I'll share about what I see in my practice is that there are oftentimes cultural, linguistic, economic, literacy barriers that a parent has to overseeing the best interests of the child or the young person. And if let's say the working parent or the parent who speaks English or the parent who has a driver's license, if that parent becomes detained, the fact that there is a custodial parent who is not detained doesn't necessarily mean that that person has access to providing for the well-being of the child. So that is why we support the current drafting, which only requires an adverse immigration action to one custodial parent, so that families can have that flexibility to meet their individual circumstances. There's a question that was raised about what happens if parents don't try to reunify with their kids, or if ICE leaves children behind. As has been law for decades in the United States, since the 1990s, when President Bush signed into law special immigrant juvenile status, there's actually immigration legal mechanisms to help children who are not able to ultimately reunite with their parents to access permanent residency and citizenship and move on with their lives. This isn't a question before this committee, whether that's a good policy. That's for Congress to decide. But it has been very clear that that mechanism exists, and that is a part and parcel of my legal practice that I've been providing services for here in Vermont for years now. And from the perspective of the economy, it's certainly been really helpful to watch those young people access regularized status and social security numbers so that they can go to college and pursue their professions and open businesses and contribute to our community and economy in all the ways that we know young people do and young workers do, in a way that our future economy relies on. So there is a mechanism. It already exists. It's existed for a long time. And I suppose, I don't like to divine what comes in the future of federal immigration enforcement. I suppose if that ever changes, we should have another hearing and talk strategy here. If jurisdictions, go ahead, Chair
Yeah,
Lon.
before you go to the next question, Tom has a
Quick question. As far as standby guardians go, what are the bare bones requirements that they are going to have? Do you know?
I would defer to Vermont Legal Aid on that issue. They are really the subject matter experts when it comes to guardianship proceedings. I'm not sure if there's a specific question that speaks to my expertise as an immigration lawyer that you're asking.
Well, I would think, would they have to be a U.S. citizen?
I don't believe so, no. I mean, currently, no, right? Since the 1990s, special immigrant juvenile status is not required. I mean, family law and probate law are matters of the state. So it's really up, what we have seen is that because there's not an immigration question at issue, immigration status has not been relevant. The Supreme Court and Congress has made clear that immigrants have constitutional and civil rights regardless of status. And so exercising your parental rights over the care, custody, and well-being of your children is one of those protected rights available to everyone.
Okay, thank you. So just real quickly, I think we heard testimony from Barb Prine yesterday that if the potential guardian is also undocumented, they actually really counsel against having somebody who is an undocumented immigrant to take that position, because they could be in danger of being an adverse action as well. So it's a little bit different than your question. I just want to remind us of what Barb had testified to. So back to you, Jill.
No, thank you, Chair Lalonde. And I can comment on that point. I mean, I agree. So, the way I talk about resource constrained legal service delivery is there's like best practices and then there's the floor. And we tend to float somewhere in between because of the reality of resource constraints. And I certainly agree that a young person, if they have available to them an in status guardian, that is the best practice, because you wouldn't want a guardian to present themselves in a probate matter and then immigration enforcement use that information against them to put them into removal proceedings that wouldn't serve anyone, that wouldn't serve the adult or the child. The reality has been that sometimes that is what's available to folks, and people get to make their own decisions. And so I try to provide as much information as possible to families to make the best choices for themselves. I think what I have heard, guardians who are underdocumented or at risk, who take on the responsibility of sponsoring a young person, what I hear their cost benefit analysis is like, undoubtedly, if you're centering the care and well-being and need the best interests of the young person, the idea of a young person being put into an institutional setting where they can't communicate linguistically, where there's cultural barriers, religious access barriers in a group home setting, that would be the worst outcome, second to an unnecessary removal. So I agree with Barb that we warn people of the risks, and the best practice is certainly, if a guardian who is in status is available, that's who we pursue.
Okay. Did you have more? You were still covering a few things, I thought, or maybe I'm misunderstood.
I feel like I've touched on
Okay.
the points, and I can also share my written testimony with the committee after the hearing.
Oh, okay, great. Any additional questions for Jill? No, thank you very much. It's very helpful. I think that clarifies a lot of things. So we'll end with Steve Crofter. Thank you, Steve, for your flexibility and being able to come back this morning to weigh in. If you could identify yourself for the record and proceed.
Sure, thank you. Yeah, my name's Steve Crofter, and it was good to be with you all yesterday, and I noticed how much I appreciate all that you do as legislators, and I recognize how hard. I mean, I'm sure I'm not completely, but I got a glimpse of how hard your jobs are, and yet from a lowly citizen's point of view, a lot of good comes out of Montpelier, and I really appreciate you working across party lines, which I don't see coming out of Washington so successfully. So anyway, thank you for what you do. This part of the bill that you're working on about the standby guardianships for people in immigration affected by immigration actions, it's pretty clear to me, unlike some things that affect all of Vermonters or many people, in terms of sheer numbers, this probably doesn't affect that many people, but my impression is that the difference it makes to those few people it does affect is absolutely huge. And I'm not a professional or some kind of expert, but I have gotten to see what this standby guardianship means to one family. And I just want to share that personal experience with you. In January, I heard about Vermont Legal Aid, sort of beginning these standby guardianships, and presented that idea to a family of asylum seekers that I know, and they were very interested. So we explored it more. This is a family who is here in the United States legally, seeking asylum. They crossed the border with permission. They underwent a credible fear interview to show that they had credible reason to fear returning to their own country. They followed all of the requirements to be here in this country. But they're still terrified. They do not feel safe in terms of immigration proceedings. And I think that's a reasonable, I understand that just simply based on the fact that in the news, there are a number of cases in which other people who are here in the United States legally are detained, deported, et cetera. So it's reasonable for them to be afraid of what might happen with immigration actions. So we went ahead and set up, I sort of helped facilitate through Vermont Legal Aid. We found an attorney, and that attorney set up a standby guardianship with him, with someone who knows their and is familiar with the whole family, including their 6-year-old child. And I just got a sense of how relieved they were to set this up. But it was about a month later that I got a deeper understanding, because well, first I just want to ask, how many of you are parents? I mean, I'm a parent. Any of you have children? Some of you do. So what happened a month later was they were called in to report to the ICE office in St. Albans for a routine check-in. Seemed reasonable enough. But they were terrified of the idea of actually presenting themselves at an ICE office. ICE had been clear that they did not need to bring the child with them, which seemed like a good sign. Like, you wouldn't think ICE would plan to deport the parents without the child. But then again, they're aware that that has happened. So they were, as I said, they were terrified. The appointment turned out well. ICE was friendly. It was routine. The appointment wasn't a big deal. What was a big deal was that morning. We had to leave about 5 o'clock in the morning. The weather was bad to get there to St. Albans by 8 o'clock. We left at 5 in the morning, and at 4:30 in the morning, they drove over to the home of the standby guardian with their 6-year-old daughter. And they told her, in effect, we plan to be back this afternoon, but if we don't ever see you again, you know this person, she will be your mom. As a parent, I can't imagine having to say that to a 6-year-old child. And yet, when we talked about it, it was really clear having to do that was less terrible than not having had this plan set up. And that's what I want to leave you with. It was that important to this family to know that if they never saw their daughter again, or if they were separated for some lengthy time until they were able to reunite or something, their daughter wouldn't be in some nameless system of the state. The daughter would be with someone she knew and trusted and would care for her, and would have the wherewithal to get the daughter reunited in another country. So thank you for listening to that experience.
Thank you. Thank you for sharing that with us as well. Any questions for Steve?
No, not a question, just want to say thank you, Steve, for relaying that story and for being, a proactive, compassionate human. And, we need all of those in the world that we can get. So thank you.
We all have a role to play there. So thank you. And thanks for doing your part.
So, and I guess to put a bow on this, that this legislation really clarifies the process for a standby guardian in that scenario would have actually gone through this process if they had needed to do that to become a legal guardian as well. So, so I appreciate that. So, any other questions for witnesses? So, at this point, I'm going to try to have a straw poll on this afternoon. It is on notice calendar today. We'll be on the floor tomorrow. I hope that we can go ahead and concur with it and get that done tomorrow. But we can talk after the floor. It should be a relative relatively short for again. So we'll pick that up after. We'll also do the H41, the abuse of a dead human body bill. Tom Burnett's not here today, so I'll be asking for a delay of one legislative day. I conferred with Tom. He wants to still be the one presenting it. And we'll try to do a straw poll this afternoon as well, but rather than, and I can informally get Tom's vote on that. So, all right, so we're going to take a 10-minute break and then we'll move to S12. So thank you.